Ladies and gentlemen, thank you for standing by. Welcome to Ring in the New Laws Key California Harassment, Discrimination and Consent Mandates webinar. During the presentation, all participants will be in a listen-only mode. If you'd like to ask a question during the presentation, please use the chat feature located in the lower left corner of your screen. If you need to reach an operator at any time, please press *0. As a reminder, this conference is being recorded December 11, 2014. I would now like to turn the conference over to Adam Langley. Please go ahead, sir.
Hi, everyone. I'm Adam Langley, Marketing Associate here at Workplace Answers, and I'd like to thank you for joining us for today's webinar, Ring in the New Laws, Key California Harassment, Discrimination, and Consent Mandates for 2015. This webinar is brought to you by Workplace Answers, and presenting today is Sondra Solovay. For those of you not familiar with us, Workplace Answers provides industry-specific compliance training for enterprise, higher education, and government organizations. Human resource leaders and risk mitigation teams trust our award-winning training content, services, and software to develop more engaged workforces and minimize exposure from complex legal requirements. Just a couple housekeeping items before we get started. You may submit questions to the speaker at any time today by typing them through the chat feature located to the left of your screen. Questions will be addressed at the end as time allows, and although we will not be able to provide the actual PowerPoint slides, all registrants and attendees will receive an email within the next week or so with information on how to view the archived recording of the webinar. You may receive a call from one of our consultants after the webinar to get your feedback and see if there's any ways we might be able to help you with the issues discussed in today's webinar. And we're really excited to have today's presenter with us. Sondra Solovay has been teaching, training, and consulting on diversity and discrimination issues for almost 20 years. A graduate of both UC Berkeley's Bolt Hall School of Law and Brown University with honors, Sondra's legal work has been honored with several awards and profiled by San Francisco Attorney Magazine. Sondra's book, Tipping the Scales of Justice, was the first published exclusively on the topic of weight discrimination in the law. She's also co-editor of the award-winning anthology, The Fat Studies Reader. Her writing appears in the Harvard Business Review and Business Spotlight magazine. Sondra's frequently quoted by the media on discrimination and bias issues, including interviews on Good Morning America, Wall Street Journal Reports, Court TV, The O'Reilly Factor, MSNBC, NPR, and the New York Times, to name a few. Sondra serves as director of the product development team responsible for creating Workplace Answers award-winning course content. So without further ado, I'll turn the call over to you, Sondra.
Great. Thank you so much, Adam. I'm really happy to be here talking to everybody about some of the key new laws. California has had a very busy session, so there are numerous laws that we'll talk about that impact the workplace and even the higher education environment. I'm just today highlighting key changes that will have an impact on most workplaces and those that could cause significant legal or public relations damage if you miss them. So we will do this pretty quickly, and we'll be covering these 5 laws that you may have been hearing about. We'll start with AB 2053, Abusive Conduct Awareness. This is impacting harassment and discrimination issues. We'll talk a bit about the context of abusive conduct in the workplace and what it means for those of us in California or those of us who have employees in California, even if we are not. Next, we'll shift to talk about AB 1443. This is the Volunteers and Interns Bill. We will then talk about AB 1660. We'll just talk about this briefly. This is the Driver's License Non-Discrimination Bill. followed by a short mention of AB 1792, which prohibits certain kinds of public assistance discrimination. And again, we'll just talk briefly about those, even though the rule of law is more complex. For our purposes, we'll just make a short mention of it today. And then we'll look at SB 967. This will have a slightly longer discussion about the bill and its merits and concerns. This is a controversial law nicknamed Yes Means Yes, and even if you're not in higher ed, I really encourage you to stay for that discussion. It won't be very long, and it is extremely interesting. This bill has been gaining national attention, and certainly if you or your friends have children in college, it's highly relevant, even if it's not your workplace. Let's jump right in. I wanted to take a moment to talk about abusive conduct in the workplace. Now, other countries have had anti-bullying laws for quite some time, sometimes using the language of mobbing. You may have heard about that. There are different definitions of bullying and abusive conduct. We'll look at the California definition closely in a moment, but I want you to get a general sense about what kind of behavior we're talking about. So we're talking about a pattern of behavior or health-harming maltreatment that's threatening, humiliating, or intimidating, or that interferes with work or is verbally abusive. There was a study out of New Zealand that talked about it as unwanted and unwarranted behavior that a person finds offensive, intimidating, or humiliating and is repeated so as to have a detrimental effect upon a person's dignity, safety, and well-being. So those are the general definitions of workplace bullying. In the U.S., we're just now really turning our national attention on bullying, and we're seeing that in the workplace. So there are a lot of different studies about workplace bullying. I pulled this one because it's very recent and it gives you a general sense, although this is not the most scientific of the studies. It is just a poll, but I want you to get a sense of what other people are finding in the workplace. So prevalence of bullying, 28% in the private sector. As you might expect, certain populations are experiencing bullying at higher levels. 44% of physically disabled workers reported it in this poll, 30% of lesbian, gay, bisexual, and transgender workers. Rates were higher among African American and Hispanic employees compared to white male employees. And this poll found the highest rates existing among those where their high school degree was the highest education level achieved. There was a slight dip for folks who had an associate's and then a slight increase for people who had bachelor's or higher. Other studies show that workplace bullying in the United States is on the rise, and that people who are seen as less conventionally attractive are more at risk for workplace bullying. So there is a lot of information out there, and again, we're not going to go into too many details. I just wanted to give you a general flavor. Okay. So let's now shift into the law with that kind of as the background. And let's review some of the basics of AB 1825. This is the 2-hour sexual harassment prevention training requirement in California. It applies to employers with 50 or more employees. AB 1825 provides very detailed information about the topics that have to be covered in the training. Within 6 months of an employee gaining supervisory responsibilities and every 2 years thereafter, they have to have this 2-hour training. And it's modified by AB 2053 to add abusive conduct information. So that's the basics. Let's move on to talk a little bit more now about AB 2053. This rule takes effect on the first of the year, 2015. It requires sexual harassment prevention training to include prevention of abusive conduct as a component of the training and education. And it is this great national and international focus and awareness of bullying that sets the stage for this new rule. Okay. Now, there is a definition of abusive conduct that's provided, and we will go into that. But before we do, I wanted to talk a little bit about what AB 2053 does and also what it does not do. So, interestingly, while AB 1825 provided a lot of details about what had to be in the training, AB 2053 doesn't do that. There is a requirement to train, but the details are not specified. So we know it has to be included in the 2-hour training requirement, but the law doesn't say how much time should be spent on this new material, and it doesn't say precisely what materials should be covered. It does not extend the length of the 2-hour training. So this is not going to be 2 hours plus abusive conduct. The abusive conduct is going to be included in the 2-hour total time. It does not create a private cause of action. And also notice that it does not add a new protected category to California's Fair Employment and Housing Act. So none of those things change. What really changes is that this abusive conduct has to be included in the 2-hour training. Okay, let's take a closer look right now at the definition of abusive conduct. Abusive conduct means conduct of an employer or an employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interest. Note that malice is required. So malice means we're looking for some sort of wrongful intent, like an intent to cause an injury or an intent to cause abuse. Now, especially despicable conduct might suffice when it's carried out with a willful and conscious disregard for others. So that abusive conduct can include repeated verbal abuse. Those could be derogatory remarks, derogatory insults. They could be epithets. You already know, I'm sure, to be on the lookout for epithets that have anything to do with protected categories. With the addition of the malice requirement, it means we're not looking for that kind of sort of everyday discourtesy that we've all experienced from time to time in the workplace. A communication that's simply a little bit rude isn't what we're talking about when we're talking about abusive conduct. So we're looking for something that is more significant than that. And note that abusive conduct needs to be unrelated to a legitimate business interest. So a task that's genuinely related to the legitimate conduct of business usually would not trigger an abusive conduct designation. Again, we're looking for something that a reasonable person would find threatening, intimidating, or humiliating. And one of the types of abusive conduct that's pretty common is undermining another person's work performance. So that's something to really be on the lookout for and to make sure that all of your supervisors are aware of. Now, it is the law, so of course we're going to have exceptions. And what you want to be aware of is that single act exception means a single act is not going to constitute abusive conduct. Remember, in both the general definition and in the California definition, we're looking for that sort of cyclical, repeated type of conduct. Now, of course, it is the law, so any law is going to have an exception, and you really know that you're in California when your exception has an exception. So the exception to the exception is that a single act usually doesn't constitute abusive conduct unless it's especially severe or egregious. If it's especially severe or egregious, then even one single act could qualify as abusive conduct. And I'm sorry, I should have mentioned this at the beginning, but as we go through, please don't hesitate to type your questions. and we will have time at the end where we'll be able to go over those questions. So if any of this is confusing, feel free to go ahead and type your questions, and Adam will manage those, and we'll get to those at the end. Okay. So what do you need to do? You want to make sure that your training includes abusive conduct prevention. That is the first and most important thing to do. Secondly, make sure your policies are consistent with your training. So your policies should also talk about abusive conduct and that that's not tolerated in the workplace. For multi-state employers, realize that this may mean that you want to do a larger policy adjustment across all of your teams, both in California and out. A lot of multi-state employers like to have one set of rules and policies that cover as many folks as possible. So in that case, you may be taking this California policy and spreading it across your workforce. Finally, you want to make sure your supervisors understand how to recognize abusive conduct and that those supervisors are also prepared to respond to it. Can they recognize the conduct? Are they ready to respond? What should you be on the lookout for in 2015? Well, we do predict that this legislation will be picked up in other states and that we could see California potentially create a private cause of action for abusive workplace situations. So right now there is no private cause of action, but that's something that could definitely change. And we are expecting to see this kind of legislation become more popular. Now, let me offer a quick caveat. Just because there is a clear statement that no private cause of action is hereby created via 2053, this topic, abusive conduct, really does easily lend itself to other kinds of civil rights and torts claims. So not only do you want to be sure that you're training so that you are living up to your responsibility to take all reasonable steps to prevent workplace harassment, you want to be sure that you're really equipping your supervisors with the tools they need to make sure that there aren't actions happening in the workplace that, even if they're not a lawsuit under 2053, could be a lawsuit under a different rule, like intentional infliction of emotional distress, or an invasion of privacy claim, or even an assault or battery claim. Okay, so 2053, that's a big one. It's on everybody's radar for 2015. Let's shift and take a look now at AB 1443. This is the law about protecting volunteers, interns, and similar unpaid workers from harassment and discrimination. AB 1443 amends the California Government Code, and what it does is it makes certain forms of discrimination unlawful with regard to people who are unpaid interns, apprentices, in limited duration programs. Often you might have a limited duration program that gives someone work experience with a stipend or with no stipend, and also to certain volunteers. So it's taking those laws that you're already familiar with and just making it clear that they also apply to people who are not being paid for the work that they're doing. This law was enacted really as a response to some rulings in other jurisdictions that were suggesting that volunteers and interns might not be protected under discrimination and harassment rules that were covering employees. Now, AB 1443 does not add any additional protected categories. So your protected categories are staying the same. It's just that they're being applied to additional folks. And it doesn't change employer responsibilities. So You're still responsible also for non-employee conduct in certain circumstances. You still need to take all reasonable steps necessary to prevent and correct harassment and discrimination. At this point, I thought we should just take a moment to review those California protected categories, because remember that those categories are still in place, and now we're concerned about making sure that no harassment or discrimination based on these categories applies to interns, volunteers, and other unpaid folks. Okay, so race, religious creed, color, national origin, ancestry, physical disability, mental disability, and medical conditions, genetic information, marital status, sex, gender, gender identity, and gender expression. Each of those, of course, a separate category. Age, sexual orientation, and military and veteran status. So we want to be very careful around all of the protected categories. Now, I know there's a lot of text up here on the screen. We're not reading this word for word. I just wanted to show you how the changes for AB 1443 are being incorporated into the existing law. So I don't expect you to focus too intently on this. I just wanted you to get a sense of it. You'll see here in black the protected categories are untouched. But in the orange, you can see how this additional protection is coming into place. So this is where we're incorporating the protection for people who are in those unpaid internships and other kinds of training programs, apprenticeships, or limited duration work experience. I'm not being very helpful with my highlighter, but here you can see what we're talking about. Okay. A quick reminder that aiding, abetting, inciting, and compelling or coercing discrimination and harassment is still also unlawful. So you want to be sure that neither you nor anyone in your workplace is aiding or abetting discrimination or harassment against anyone, employees, or volunteers, interns, or anyone in those new groups that are also covered. And again, here's another place in the law where you can see the impact of AB 1443. So here at the end, talking about unpaid interns and volunteers again. Okay, so that's volunteers, interns, and other unpaid folks. Let's now that we have a sense of AB 1443, move on for a brief chat about AB 1660. And I did warn you California was busy, so I warned you in the beginning. All right. To understand AB 1660, you need to know what an AB 60 license is. So an AB 60 license is a type of California driver's license that's given to certain undocumented people who meet particular requirements. And here I've got up on the screen for you a little more detail about that. So you're welcome to take a look at that if that's useful. But just keep that in the back of your mind. That's what an AB 60 driver's license is. Okay. Okay. Now, AB 1660 amends California Government Code and various sections of California's Vehicle Code relating to driver's licenses. And what it does is it makes it an unlawful form of national origin discrimination for an employer to discriminate because a person provides this type of license. So it makes it clear that discrimination based on someone for providing an AB 60 license is actually a form of national origin discrimination, which of course is one of our protected categories. Okay. It also requires that driver's license information be treated as private and confidential. Now, AB 1660 doesn't do a couple of things. It does not interfere with or override any immigration law. So you're not seeing any change to immigration law. It's just with regard to how this particular license is handled and your responsibilities with regard to someone who produces this license. It also doesn't allow an employer to demand to see a driver's license unless for some reason there's some exception of the law that already applies. So I don't think that that's a super high impact law for most of us, but definitely important to know. Okay, great. Only 2 more laws left to cover today. Let's move on to AB 1792. The mandate behind AB 1792 is that a public report is going to be created that identifies employers with workers on certain public benefit programs and provides certain public information about that. This is happening in a context where there's been a lot of social outcry about workers who receive wages that are low or where shifts are limited, so that they're working but they're essentially living in poverty and qualifying for subsidized services. And the critique there is that if the wages are low, then the public is subsidizing the cost. That's made this a hot topic in the newspapers and in the media. And that's where this fairly controversial law kind of came out of. It's not regarded as an employer-friendly law in that it's making this visible and it could shine a negative light on some employers. So this is a controversial rule. Okay. Now, AB 1792 does a couple things that you're going to want to keep in mind. And of course, this is a complicated rule. We're just covering the piece that's important kind of from this HR, this sort of narrow HR perspective. But if this applies to you, then the law itself is more detailed. And of course, we're not covering that, just this little piece of it. Just covering this briefly. But AB 1792 prohibits an employer from discharging, discriminating against, or retaliating against an employee who enrolls in a public assistance program. And it prohibits an employer from refusing to hire a beneficiary of a public assistance program because of their enrollment in that program. So as the rule is making certain information public, it's also trying to protect people from discrimination that could result if an employer was trying to change what those ultimate reports look like. So again, just something to keep in mind. If this applies to you, then it obviously is more complicated, and you'll need to delve into the details of that. So let's move on to our final law of the day. That's Senate Bill 967. This is in response to an ongoing record of significant sexual assault happening on college campuses. So in response to that, Senate Bill 967 was enacted. It applies to most community colleges, to the state university system, University of California system, all post-secondary institutions that receive state student financial aid funds. So it has broad applicability and goes into effect also on January 1st. And what it says is that these schools that are covered have to adopt policies about sexual assault, domestic violence, dating violence, and stalking that involve students. And the piece that everyone across the country has been talking about is that the policies must include an affirmative consent standard in determining whether consent was given by a complainant. And this is that yes means yes, standard of consent. So let's take a closer look at affirmative consent and what that means. You may remember the saying, no means no. Well, the critique of that approach is that a no means no approach puts too much responsibility on the survivor of a sexual assault to have said no. And with campus sexual assault all too common, this older approach has given way to a new approach called yes means yes. So with this yes means yes rule, it's actually the responsibility of each person involved in the sexual activity to ensure that they have received the affirmative consent of the other person or the other people who are involved to engage in the activity. Lack of protest, lack of resistance, those are not allowed to be taken as consent. The fact that someone has remained silent, that also doesn't show consent. So we're not looking for someone to kind of go along. We're looking for affirmative consent. A prior sexual relationship or the existence of even a current dating relationship, that's not enough to show consent. Consent has to be ongoing, and it can be revoked at any time. So we're looking for something where at each stage of the intimate encounter, the participants are actively checking to be sure that they have affirmative consent from the person or people that they're engaging with. One of the common misunderstandings about the California law is that people have to get some kind of stuffy, very unsexy verbal or written consent in order to engage in intimate activities. And that's simply not the case. It's definitely part of what's been in the media, but that's not what the rule actually says. So the rule says you need this consent that's ongoing. It needs to be affirmative. Just because you have it one moment doesn't mean you have it for an entire activity. It can be revoked at any time, but you don't have to get some kind of stodgy disclaimer or signed paper. You can get affirmative consent through gestures. You can get affirmative consent through sounds or some combination of gestures and sounds with or without words. The idea is to be checking in constantly and consistently to be sure that the person that you're engaging with is showing affirmatively that they want to be engaged with you in the activity that you're doing. So, as students go through an intimate encounter, they should be checking as they go, looking for affirmative signs that any kind of intimate or sexual activity is mutually consensual, and then that mutual consent is in existence the entire time that that encounter is happening. So this definitely, California's rule has made major headlines. It's definitely on the cutting edge of the approach to sexual violence prevention on campuses, and this is something that we're expecting to see more of at other campuses and also in other states. So a very interesting rule to combat a very and all too prevalent problem on campuses. And again, just to be clear, that has to do with students, so it's the student-specific rule. Okay. We've made it through all of the rules. I hope that wasn't too painful. The best way to handle these new legal changes and responsibilities is by adjusting your training regimen to make sure that this new information is in your training plans, that it's getting out there into the workforce, that people understand it. I hope that you've been submitting all the questions that you had as we go along, but I did want to give folks a few extra minutes in case you had some questions that you hadn't finished submitting, to just go ahead and send in your questions right now if you haven't already done so. And as those are getting organized, I just wanted to take a moment and share with you a little bit about how I got into training and education. Adam gave me a lovely introduction. As an attorney, I practiced law and just got so tired of seeing all of the legal problems that happened because of lack of training. So much of what I saw was really preventable, and unfortunately, once there's a lawsuit, there rarely are winners. Lawsuits have such a negative impact for all the folks involved, whether it's from a financial perspective or morale or even just department-focused perspective. And a good training program really can stop those problems before they happen, or worst case scenario, they can help you arrest problems while those problems are still small and manageable before they turn into a huge lawsuit. So that's where I'm coming from with this stuff. I'm a firm believer in training and prevention as much as possible, and then of course giving yourself the best, setting yourself up for the best kind of success you can have if something does turn into a lawsuit. Okay, so I'm going to hand this over now to Adam, who's going to help us take a look at some of our questions, and I'm very eager to answer this for you.
Thanks so much, Sondra. You did a great job on your presentation today. Again, if anybody has questions you'd like to ask that you haven't already submitted, just go ahead and do that now. But before we go on to Q&A, I'd like to remind everyone that along with hosting educational webinars like this one, Workplace Answers is proud to offer a spectrum of award-winning online compliance training for enterprise, higher education, and government organizations. Our courses are highly customizable and available in multiple versions designed with the unique needs of your context in mind. Our harassment and discrimination prevention catalog includes training for California supervisors on these critical legal changes for 2015, and these are available in versions for both commercial and higher education clients. If you have any questions about our courseware, or you'd like to learn more about how we might be able to help you and your particular needs, please click that button here on this poll question for Interested, Contact Me. All right. I'll go ahead and leave this open, and we'll move on to the Q&A part of our presentation. All right, we had a couple questions come in. The first question we got here is, if a person took AB 1825 training before they were a supervisor and are on a 2-year cycle because our institution requires it of everyone, would they need to take it again within 6 months of becoming a supervisor?
Okay, that's a great question. So I'm going to give you 2 answers to that one. The first is, what you would absolutely need to do is take that new supervisor, make sure that within the 6-month window they've been given the anti-harassment policy of the organization, that they have gone through that you have recorded their acknowledgement and acceptance that they've received it, and that they're going to abide by it and that they understand it. And be sure that they are, and it sounds like from the question that there's no question that there's no issue that they're definitely in that 2-year cycle, but be 100% sure that the supervisor is still in that 2-year training cycle so that they're never off. That there's no point where they go that 2-year period without having received the training. And that as the employer, you're keeping, it's your responsibility to have proof of that. So this is true if you've trained the employee, or even if you've hired an employee who had training somewhere else. The same kind of rules apply, but you want to be sure, because it's your responsibility, that the training meets the law and that you have a record of that training, that you have proof of that in the files. So that's the official answer. But what I would always recommend in these cases, because it's such a small investment in training time, is to just go ahead and train that supervisor anyway within the 6-month window. You're probably fine to not do it, but it's such a low level of investment to go ahead and do that little bit of extra training. And from that new supervisor's perspective, it's possible when they took the training because they weren't really having supervisory responsibilities, they may not have paid as close attention as they would knowing that they're technically a supervisor. So I would like to give them the opportunity within that 6-month window to revisit the training now with their new responsibilities in mind. That being said, you're probably fine not to do it, but the safer bet, for simply a couple hours of investment is to just go ahead and do that training again within the 6-month window. But that is a good question, and definitely one of the tricky things about these kinds of rules, whether it be California rules or other state rules, is how do you actually implement them and keep track of them. So it's a good question. And I'm delighted to hear, by the way, that you're training all of the employees, not just the supervisors. That's definitely the best practice.
All right. And we have time for one more short question. You said that the new California training laws don't create a private cause of action. What does that mean?
Okay, that's a good question. So what that means is it is required in California that covered employees be trained in abusive conduct prevention. But the abusive conduct itself is not necessarily unlawful. So the new rule of law didn't make abusive conduct in the workplace illegal. It just said, hey, you have to train people in recognizing and understanding abusive conduct in the workplace. So the thing to remember is, while the law does not make abusive conduct unlawful, some abusive conduct is unlawful by itself, even without any other law. So we'll see common law torts come into play. Intentional infliction of emotional distress is probably the most common one, where someone is doing something that's abusive conduct, but it actually in and of itself is unlawful as the intentional infliction of emotional distress. Or maybe it violates other harassment or discrimination laws. So you can imagine some kind of extreme bullying conduct where it is actually so severe that someone could become severely emotionally distressed from it and have a lawsuit from that perspective. So even though abusive conduct is not yet technically in and of itself illegal in California, it's definitely something that's going to affect morale and be a problem in the workplace, and it's something that could implicate other laws. So we definitely want to be really careful when we see anything like that happening in the workplace and address it as promptly as possible.
Excellent.
That's a good question.
Thank you, Sondra. Thanks so much. That's all the time we have for today. And I'd like to thank you, Sondra, again for sharing your expertise with us today. And thanks to everyone who was able to join us. If you'd like to stay informed about upcoming webinars and other free sources from Workplace Answers, other free resources we give out, don't forget to connect with us on LinkedIn, Facebook, Twitter, or our website, of course, workplaceanswers.com. We hope to see you again next time. Until then, take care and enjoy the rest of your week.
Ladies and gentlemen, this does conclude the conference call for today. We thank you for your participation and ask that you please disconnect your lines. Have a good day, everyone.